Good evening. Good evening in Lagos. Good evening in Tilburg. Good evening in Nigeria, in the Netherlands. So today we have a day 2 match between two teams. Two teams supported by as well student associations who are, of course, participating as well for several years, helping the students to represent their university. So we send greetings to them. And this is a day 2 match of the group phase in the Inter-University Law Debate Tournament. My name is Aurélien Lorange, director of the Corax Foundation, and today I will be hosting this match. And the match is between the University of Lagos and Tilburg University. They received the topic 7 days ago. We don't know yet which position they will have in favor or against this motion, knowing that it is on the theme of space law for this day 2 match and all the other match as well of day 2. So it's a pleasure for me, and I would like to start giving the floor to the students for them to introduce themselves before we move to the match, obviously. So I would like to ask Miss Grace Enchi Amarchuku. Welcome.
Okay, good evening everyone. Good evening to our colleagues at Tilburg University. My name is Grace Nachi and I'll be representing the University of Lagos for this match. Thank you.
Thank you, welcome. We have as well Mr. Ristov, Dejan Ristov in Tilburg. Welcome. No, you need to push again, microphone. Yeah.
Oops, sorry. Yes, welcome as well. Thank you so much. I would like to wish our opponents good luck, and I would like to say that I'm pretty excited. And yeah, that's about it.
Thank you, welcome. We have as well Lawrence Uchendu. Welcome.
Yes, good evening, honorable judges and my colleagues at the Tilburg University. It's a pleasure to be here once again and really do hope to have a very insightful and wonderful session with you all today. Thank you.
Thank you, welcome. We have Miss Denisa Boykova in Tilburg. Welcome.
Hello, everyone. I'm really happy to be here discussing this super interesting topic with you. And I'm so glad we could have the match today. And I hope that we have a fair and exciting competition in the following minutes.
Thank you very much. And we have as well Olaide Tosin in Lagos. Welcome.
Good evening, everyone.
Welcome, thank you for joining.
My name is Olaide.
Yes?
Thank you very much.
Yes. So we will, after our presentation, I will as well speak about the technical difficulty, what we can do about it. Now I want as well to send greetings to the coach. We have two coaches in the rooms for the Tilburg University, Dana Vasile and Benancio Aguirre Rosas. Yes.
Hello, thank you for this debate, and we're really excited to see how things go this year.
Yes, good luck for both teams.
Yes.
Thank you. They are both the former participants of last year for Tilburg University, and this time they are coach for the team. And we send greetings as well to Michael Adedayo in Lagos. I hope that you will be watching the match as well for the team. And I want as well to thank the two student associations. So, of course, the Mooting Society of the University of Lagos, who has been promoting the competition in the University of Lagos, in Unilag, I think you say, for the last 3 years already. And as well, we send greetings to Elsa Tilburg as well since the first edition. So it means into 2022, we have been promoting it. So many thanks to both student associations. And we'll have some networking activities as well between student associations a bit later in April, I think. So now we move to the match. The topic which has been sent to the teams was states should be held intentionally liable for damage caused by private commercial activities in outer space. So now I will share my screen and we'll know which position each team will have for this match. The team will be in favor. We start the match. So normally you should see that there is a wheel with two double flags. There are two chances for each institution, one chance to be in favor of the motion and one chance to be against the motion. So now I'll activate the randomizer and we'll know which position you will defend for this match. So, for this match, Tilburg University will defend the position in favor of the motion, and we start with the first introduction, while the University of Lagos will defend the position against the motion. So it means concretely, Tilburg University will defend the position that states should be held internationally liable for damage caused by private commercial activities in outer space, while the University of Lagos will defend the position that states should not be held internationally liable for damage caused by private commercial activities in outer space. Now you will have 5 minutes, both teams, to review your notes, and then we'll hear the introduction by the team from Tilburg. Okay, so we are done with the 5 minutes of operation, so I stop sharing my screen. So before we start officially the match, I remind that when you see the yellow card, it means you still have 30 seconds in your speaking time. You can continue to speak, of course. When you see the red card, it means that your speaking time is over. You may finish your sentence, but please do not start a new one, otherwise the judge might penalize for going over the time. So now, for the introduction, this is Tilburg University, so I will give the floor to your team in a few seconds. So I give the floor to the Tilburg University debate team. For your introduction, you have 4 minutes.
Thank you. Honorable judges, respected opposition, today we stand before you to argue that states should indeed be held liable for damages caused by private commercial activities in outer space. Now, to substantiate our position, we bring forward two arguments. Argument number one claims that states holding states liable ensures procedural fairness and legal certainty. Argument two claims that states being held liable will therefore strengthen the regulations, which will benefit not only the global community, but also companies themselves. Now, let us begin by examining our first argument regarding procedural fairness and legal certainty. Now, the current international framework is based on Article 6 of the Outer Space Treaty, supported by the Liability Convention, and it explicitly confers the state's responsibility for ongoing oversight obligations on all space activities, which includes private parties. Furthermore, Article 8 of the same Liability Convention specifically allows compensation claims directly against launching states, which anchors the dispute in public international law. Now, why is this so important? Well, because with such framework, there's a clearly defined jurisdiction, and it directs disputes to reliable international courts, such as the Permanent Court of Arbitration, the WTO dispute resolution body, or the International Court of Justice. This means that victims have a clear and reliable path to justice. And it also means that there is a sovereign equality between the states, which means that both state parties to the proceeding, are held on equal footing. This arises from Article 2.1 of the UN Charter. Now, imagine if the platform for such claims was private international law. Well, that would lead to numerous procedural hurdles. Parties would face constant jurisdictional disputes. They would have conflicting judgments from different national courts. They would face abuses by more powerful parties which have more resources. Such legal ambiguity severely undermines the principle of legal certainty and also undermines fairness. So clearly, holding states liable ensures stability and fairness to resolving disputes caused by private space activities. Now, turning to our second argument, we believe that holding states liable promotes better regulation. And we have examples to back up our claim. So let's consider the case of Lopez Ostra versus Spain. This is a case from the European Court of Human Rights, in which Spain was held accountable for its inadequate regulation of a polluting private facility. Now, what happened was after Spain was found liable, basically Spain enacted a law, which was the Law 16/2002 on integrated pollution prevention and control. This clearly demonstrates that state liability drives regulatory improvements. It ensures more effective oversight of private enterprises. But do stricter regulations actually benefit the private sector? Indeed, they do. A study by the European Securities and Markets Authority shows that firms with higher environmental, social, and governance ratings, also known as the ESG scores, significantly improve their financial performance and reduce client costs over time. Now, this basically leads to the conclusion that strong regulatory frameworks foster safer operations and more profitable businesses because there is a predictable business environment. Now, honorable judges, shouldn't states be the ones guiding private companies towards safer, more profitable practices and ensuring a better regulatory standard for all citizens? In conclusion to our statement, we would like to say that holding states accountable for private commercial activities in outer space is not merely fair. It actively promotes regulatory frameworks that enhance both safety and economic prosperity. Thank you.
Thank you very much. Now we hear the introduction on the side of the University of Lagos. For your introduction, you have 4 minutes.
All right, can I confirm that I am both visible and audible?
Yes, both.
Thank you very much. I'll be starting now. Just 24 hours ago, this planet was subjected to an explosion from a SpaceX rocket launched from Texas. This rocket explosion sent harmful debris raining over the Caribbean Sea island. Tell me, what justice did the present framework afford us? What good did state liability do to prevent this catastrophe for the second time in less than 8 weeks by the same private entity? Good evening, honorable judges and my counterparts at Tilburg University. Today, my colleagues and I argue that states should not be held internationally liable for damages caused by private commercial activities in outer space. My personal argument has three arms. One, the existing liability is ineffective. Two, state compensation falls short of the needed solution. And three, there is an expediency for the solution needed. Firstly, the existing liability regime is ineffective. Contrary to my counterpart's claims, in nearly half a century since the adoption of the Outer Space Treaty and the Liability Convention, only one country has been held liable, despite numerous incidents causing grievous harm to both terrestrial and space environments. Within the space of less than 8 weeks, there have been 2 spaceship explosions from the same private entity. This stark accountability gap reveals that states have largely failed to enforce their supervisory obligations over private commercial activities in outer space, leaving catastrophic damages unremedied and our global commons at increasing risk. Where were the states when environmental devastation struck, and why have they not stepped up to fulfill their responsibilities under these treaties? This is a failure on their part. 2, state compensation falls short of the needed solution. The Liability Convention, which holds state liable under Article 2 and Article 3, has been invoked only once, in 1978, and in relation to the Cosmos 954 incident, which involved the explosion of a Russian satellite carrying a radioactive material across a vast land area. Now, this radioactive material was spread across the territory of Canada, and Canada spent over $6 million to fix damages and prevent potential harms. What did the Soviet Union do? They only agreed to pay an ex gratia sum of money. Do you know what an ex gratia sum of money is? Honorable judges, this is money paid out of favor just for the benefit of it, for moral obligation. Lives on earth were put in potential risk of harm from radioactive materials, lands rendered unusable, means of livelihood lost, and the perpetrators only gave compensation out of moral obligation just to fulfill all righteousness. These are people's homes and lives you are risking here. We need to hold private entities to the full consequences of their actions. On the third leg of my argument, you have the expediency of the solution needed. Judges, what is one practical outcome of holding a state liable for these activities in question? I submit that the international community hopes that by so doing, such liability is represented in the corrective and preventive measures to tackle the rising challenges of private commercial activities in outer space. However, in light of the recent challenges and urgency of this matter and the steep increase of participation by private actors, this regime does not afford us the expedient solution that we need. We cannot bank on the ripple effect expected from holding state liable when we live in a world where explosions of spaceships can occur as frequently as a civil servant receives his salary. The explosion is a stark reminder of the growing catastrophe that threatens your lives and mine. We are not dealing with mere statistics here. Human lives are involved. We need to go straight for the perpetrators of these activities. Honorable judges, when all is said and done, the question before us is, what do we stand to gain by placing the future of our planet in solutions that have failed us for nearly half a century now? The realities are different from 1970 and 1960 to 2025. The realities are absolutely different, and the crux of our problem here is perpetrated by private entities. Let us not leave a burning house to chase stray dogs. Arguing from Lagos, Nigeria, we firmly oppose holding states internationally liable for damages caused by private commercial activities in outer space. Thank you.
Thank you very much. Now we move to the first rebuttals. We hear first the rebuttal by Tilburg University. You have 2 minutes.
Yes, we would first like to point out that the honorable opposition mentioned that states should be held liable because, quote, that private parties should be held liable because states have been inefficient to do so. Yet I would like to remind the honorable opposition that there is yet to be established a system in international law which actually refers to claims directly to private parties. Most of the time, actually, and this is regarding your claim that the framework is outdated, most of the time in international law, still to this date, the states the primary platform to which compensation is sought for private actors' wrongdoing. Furthermore, you said that there has been only one case. Yet, we would also like to remind you that commercial activities had not been an often something that has happened really often, and then incidents arising out of commercial activities are numbered to the below the tens. So we would like to state that, for example, according to the European Directive on Environmental Liability, with regard to the prevention and remodifying of environmental damage, the state is still the main platform for ensuring that remedies be made available as per Article 7.3. Also, we would like to basically explain that while states have not been held responsible for those instances, most of the times when there is a problem between the two states, there is a diplomatic solution in which the states basically agree to some sort of a decision. For example, one state is going to compensate the other, and then basically there is no claim brought into the international authorities. Now, contrary to what you just said, that basically we need a new system that will enforce the opportunities to sue private actors. We would like to remind you that suing private actors in international law can only happen through private international law, and private international law is the hardest platform to do that because there are so many jurisdictional problems to establish a jurisdiction, to establish the court, etc. Thank you.
Thank you very much. Now I give the floor as well to the University of Lagos for your first rebuttal. You have 2 minutes.
I would like to confirm that I am audible and visible.
Yes, you are.
Thank you very much. Judges, the proposing team have submitted that there is no international body liable for holding private companies responsible. And we agree that that is correct. There is currently no current overarching body to hold such private companies liable. And this is why we would like these judges for you to draw inferences from what happens in environmental law. Currently, we have the United Nations Guiding Principle on Business and Human Rights, and under this framework, private companies can be held internationally liable for their actions and wrongs that cause damage to the environment. We would like to reflect these principles, particularly in environmental law, and this is due to the fact that the Liability Convention does not provide any form of provision for damage that is caused to outer space. Damages under the Liability Convention is only restricted to personal damage, property damage, and loss of life. There is no provision for protecting the outer space environment. And this is so dire, especially with the accumulating number of space junk that is in the environment, in the outer space. So then, on this ground, who do we hold responsible? Who is going to pay the cost? The solution to this, as we once again submit, is that these private companies are held personally liable, reflecting what is already happening in environmental law, also in space. Also, the proposing team has submitted that by holding states liable, there's going to be clearly defined jurisdiction and it will be clear and reliable. However, there are some questions I would like to ask. First, if the aggrieved party is a private company, would they then have to wait for the respective state or the relevant state to institute an action before they have any cause of remedy? What are they going to do when the state fails to take up such an action? Also, as seen from the Barcelonian Tractions case, such states have to have sufficient interest in the subject matter, meaning that it must be their property or loss of life that is damaged. So this means that in situations, thank you very much.
Thank you very much. Now we are moving to the second rebuttals. We start with the second rebuttal by Tilburg University. You have 2 minutes.
Honorable judges and esteemed opposition, we would like to begin by addressing the example made by our opponents regarding environmental law. What we want to mention is that environments, such as, for example, a country's mountain or a country's river, are not common domains. The reason why it is so easy to hold corporations liable is because there is the particular jurisdiction of the country which is able to impose that on a national level. However, we should be more focused on looking at an example which is applicable to the situation, one of a common domain. We would like to propose to you the law of the sea. Under Article 139 of UNCLOS, which is the governing body for law of the sea, states are held internationally liable for damages caused by companies registered in them. This is done so because such a common domain as the sea is needs to be regulated by the states which have claims to it. This can be translated to outer space. You mentioned that we should be careful about the environment of the cosmos. Yes, but that is the domain of humans, of people. And states are the ones who represent people, which is why states should be put together, held liable, in order to decide the future of outer space law. This is this argument we're raising because, as given the example by Law of the Sea, the law exists because of cases which were decided between states. Now, law of space law will develop because of cases decided between states as well. We also want to mention that our opponents propose no framework for how liability will be transferred to companies in order to satisfy claims against them. It is such a big level of responsibility that it is only states who are capable of actually handling it. Thank you.
Thank you very much. Now we hear as well the second rebuttal on the side of the University of Lagos. You have 2 minutes.
Okay. I'd like to once again confirm that I am audible and visible.
Yes, you are.
Very well. The proposing side has stated that states represent people. However, judges, how practical is this? Especially since these private actors are furthering their own personal interests and acting for profits and cost-efficient requirements. Also, how practical is this when these private companies are not agents of the states? If we do not hold these private actors liable, they will continue to be reckless. And what is the result of their recklessness? Destructions of satellites and other spacecraft that are necessary for furthering the development of human life on Earth. It is on this ground that we submit that the private companies should be held personally liable. Also, the proposing side has mentioned that the general principles that are earlier stated does not apply to global commons. However, these guiding principles specifically said environment, that is regardless of whether it is within a state's territory, whether it is within the high seas or even Antarctica, that constitute global commons as well. What we are saying that is that in the absence of an existing framework, we can mirror this principle to hold public and private corporations liable for the damages that they have done in space. These are as assertions, Your Excellency. And lastly, we would like to assert that where we hold these private actors liable, it is going to encourage them to innovate responsibly. However, if we hold the states liable, it is going to lead to a crackdown of innovation. Let me paint a scenario for you, judges. Supposing there are like 5 private space companies in a state, like in United States, where we have SpaceX, ULA, among others. If the United States is faced to pay the brunt of the actions of SpaceX, and since the United States is heavily regulating what they do, the United States is going to crack down on all the private space companies. This means that all the private space companies are going to bear the brunt of SpaceX actions. Therefore, this is why we submit that every private company should be held to pay their price. Thank you.
Thank you very much. Now we move to the conclusions. So we will hear first the conclusion by the team from Tilburg University. You have 2 minutes.
Thank you, honorable judges, esteemed opposition. In our arguments, we have demonstrated that states should be held internationally liable for private commercial activities in outer space. We demonstrated that this ensures fair procedure and legal certainty because public international law is an easier platform to address such global issues. And we also mentioned that it gives a clear avenue for attributing jurisdiction and competent court in order to continue with proceedings. We talked about how states will strengthen regulations on companies as a result of their international liability, which goes contrary to what our opponents mentioned about companies running rogue and having no one to control them. And we also gave the example that, according to European studies, regulations help companies, they help businesses grow, and they help economies develop. Now, our opponents mentioned in horrible apocalyptic scenarios of companies becoming so powerful, exploding satellites, running rogue, doing whatever they want, and not being held liable for it. This does not happen in real life. What happens in real life is countries such as China and Russia testing anti-satellite explosions, causing debris, and creating problems for the international community. Now, it is states who have the biggest capacities to cause troubles on international level for space. Our opponents also talked about how innovation will crack down. However, this is not true because regulations will become tighter. Once again, this will support businesses. And our opponents also mentioned that space companies such as SpaceX will become so giant and will overturn almost state programs. But this is not true because companies such as SpaceX are subsidized by states. This means that states are responsible for them and should be held liable for their actions. Thank you.
Thank you very much. Now we hear the conclusion from the side of the University of Lagos. For your conclusion, you have 2 minutes.
Before I commence, am I clear and audible enough?
Yes, you are.
All right. Honorable judges, while international treaties place initial responsibility on states, we must ask ourselves, where does true accountability lie? With states or the corporations directly causing potential harm? To truly foster responsible innovation and ensure swift redress for potential harm, we must shift focus from the abstract concept of state responsibility to the concrete reality of corporate liability. Honorable judges, we have made our case. States should not be liable for damages caused by private commercial activities in outer space. We have been able to prove our case from 3 strong points. Firstly, we pointed out the insufficiency of existing liability, and it has not been able to address any issue since the Cosmos 954 case. Secondly, we addressed the issue of state compensation, falling short of the needed solution. We referenced the ex gratia sum paid by the Soviet Union, which did not even cover the full of what Canada spent to clean up the mess they caused. Lastly, honorable judges, we looked at the expediency of the solution needed. We talked about how the liability on the state will not yield urgent reaction. Therefore, honorable judges, contrary to what our opposition has said, we believe that for a truly responsible space age, corporate liability is non-negotiable. And to this extent, we refuse to be affirmative. Thank you.
Thank you very much. So we just heard the 2 conclusion of each group, each team. So it means from now you are not under evaluation by the judge. So you can rest, you can relax a bit. We'll do a bit of networking. You can reopen the camera as well in Lagos and Mr. Christophe as well. And yes, we'll ask for your impression about the match. We think again the 3 judges will be watching the match and rewatching during the next 2 business days until Tuesday. And now it is time to hear your impression on this match. Grace Nachi Amara Chukwu, what do you think about the match?
Wow, I thought the match was very intense. Honestly, doing research for this topic was a bit tedious, but I have to say that our opponents, they made a very strong argument, and I actually enjoyed just trying to pick and see what I could do to support my team. Thank you.
Thank you very much. Miss Denitsa Boykova, what do you think about the match?
I was very challenged by the topic. I found it extremely interesting, but also extremely complex to navigate when we were doing research, Diane and I. I think the match was extremely dynamic. All of us were speaking nonstop with so much new information coming and coming. And I think, especially congratulations to our other team. They had just quite a strong framework of what they wanted to say, and they were very good at pushing it. So yes, thank you.
Thank you very much. Lawrence Uchendu, what do you think about the match?
I think it was a very insightful session. I mean, the topic is one that cuts across an area that is very relevant in today's world, and also to a lot of prevalent and rising issues, especially with the private commercial activities, which is a relatively recent matter in international law. So it was very insightful making research, and I really enjoyed the arguments of the opening speaker and the rebuttals. I have to commend them for their research and their thoroughness. It's a truly insightful session. Thank you.
Thank you very much. Mr. Christophe, what do you think about the match?
Yeah, I mean, I personally enjoyed the intensity of the match. I think we had different frameworks for argumentation. They obviously emphasized one framework. We emphasized another framework. We had to sort of rebuttal each framework. And yeah, it was also, I would like to congratulate them on being very intense opponents. I saw a lot of rhetorical activity from them, which was, yeah, commendable. Yeah, I enjoyed it, and believe that it will be beneficial if we can foster some extra contacts as well. And yeah, congratulations again. I think it was a very good match.
Thank you very much. And of course, we have as well Olaide Tozin. What do you think about the match?
To be sincere, it was a very, very intense match, and congratulations to both teams. Because it's really, with this match, it really, really shows the level of our research, and that I respect so much. I really wish you to
Thank you very much. So, of course, we send greetings to the coach because they support the teams and they explain as well the format of the competition before the competition started. So many thanks again. You will receive the results, of course, next week. And we send greetings again for the judge. It will be tough to assess because it was very dynamic, this match, I have to say. So good luck to the judge. And concerning the next match, so match of day 3, it will be on international trade law. So you will receive, of course, the topic a week in advance. And yes, so that will be, I think, the University of Bologna will have the match against Tilburg, and that will be the University of Lagos will meet the University of Zambia. So that will be the day 3 match. Now a bit of networking, so before we close the session. I will have a question for each team first. I will group my questions to be much easier this way. Tilburg University, did you watch any other match? Did you notice, I would say, strategies inspired you maybe? Did you discuss a lot as well with previous participants who are your coach in order to prepare this competition? And finally, do you have any person you would like to thank? And in case, it's a lot of questions maybe, in case the team from Lagos comes to Tilburg, what they should visit and drink and eat? So you can split, you are 2 persons. So who wants to start? Please go ahead. Yeah.
Yeah, so I would like to thank our coaches who took the time yesterday to sort of evaluate what we've done. They really helped us with their advice. We honestly, like, even now, we felt a little bit like we didn't know what we are getting into, sort of, but their advice really helped us get orientated with what's coming for us. And regarding what they should visit, I mean, probably just I don't know. There's a bunch of bars at the center. You can also visit the university. I think it's like good enough. And yeah, that's it. I would like to leave the floor to my teammate as well.
Ms. Borikova?
Yeah, sorry, could you remind me of the rest of the question?
Yes. Have you watched some other match of the competition? Maybe a match, the first match of the Lagos team or other teams? And would you like to thank someone, family, friends, debate club professors, whoever you want?
So we've mostly focused on talking with our coaches about previous matches and about their experience and how we should structure. So they undid that already, but I would really, really like to thank them for helping us and navigating us through how this is done because it's still our first exposure this match to the competition. And I don't know, about eating and drinking, I guess Netherlands is quite famous for cheese and it's full of super interesting shops where you can try basically everything. And we have a lot of beer. I personally like cherry beer. If you want to go drink cherry beer, feel free to come visit us. I think you'll enjoy it. Yeah, thank you.
Thank you very much. Now, same questions for Lagos team.
Okay, so I think I would like to first start by saying that there's a saying over here that you cannot raise a child without drawing from a village. So it takes a village to raise a child. Just saying that because we have had a lot of assistance along this journey. We currently have one of our advisors and coaches here with us. Our second coach is not available, but they were truly supportive on this journey. I would really like to thank them and our friends who, at some point, chipped in one or two things, helped us monitor our progress and make sure that we improve from the last performance that we had. Also, thank my teammates here for being so supportive. It's been a very long journey meeting with them. And with respect to what to eat and drink, I think I'll leave it to my colleague over here to go into that.
So, in food, honestly, like I would just recommend what I'm going to recommend what I'm going to eat right after this match. So I'm going to try amala and ewedu. Yeah. Come to Lagos, please, you must try amala and ewedu. Also try our jollof rice. We have the best jollof rice in West Africa. You heard it from me. Yeah. So, but in addition to what I said, there's some people I would like to thank. I would like to thank Aminat. I would like to thank our coach Michael. I would like to thank David, Precious, Shalom. Also was Ayotunde. It literally took a village for us. So. And our staff advisor. Yeah.
Thank you very much.
Thank you very much. Just like my colleague has said, it took us a lot of we had a lot of help. Yeah. To me, it's more or less like this competition compared to the last competition. That I can see this part. It's very much considering that it's not an easy feat. Kudos to you that. Yeah, and so the food pass. I'm just going to go.
Yeah, Ambala and Iwedu is the one. Yeah.
Thank you very much. So that's an opportunity indeed to keep contact and in touch. You can find each other as well on LinkedIn when we announce the different teams and groups. So please do not hesitate between the Mooting Society as at Tilburg. You might invite each other to have guest speakers, guest lectures, something that, for example, we do not have much here in Europe, but I had once in the university where I teach in The Hague. It was comparative African law. And that was given by a professor from Nigeria, and but yes, like their comparative European law and American law, etc. So yes, it's a way, for example, for the students to learn through the student associations. So we are very happy to have at this match, so day 2 match. Again, you will meet Bologna, you will meet University of Zambia. That was a match. I mean, they had their own match 2 days ago. So, yes, you want to say something, Mr. Christophe? No.
Yeah, we do have a question about, is there any response from the University of Bologna regarding your rescheduling?
Not yet, but I will push them just to today, because as I am...
okay, yeah, we appreciate it. Thank you.
Yes, for the 19th, it was that date, right? 19th.
It was for the 18th, we proposed just an earlier start hour, yeah.
Oh, okay, yeah. I will tell you as soon as they reply. They are reactive normally, but maybe
thank you.
Exams. Thank you very much. Again, it was a great pleasure. We keep in touch. You will see the topic 7 days in advance, and of course the grading rubrics. As I said this year, as soon as we have 2 grading rubrics, we send them already. And of course, the complete result comes when there's a free grading rubrics, a free judge. Yeah? Many thanks. It was a pleasure, and I wish all of you a great weekend.
Thank you very much.
You're welcome, and enjoy the food, of course. Thank you. Thank you very much.